the purpose of this this particular conference was on special education leadership in the law. I thought, well, at this point in the history of special education law, the most important thing has just occurred, and that is the Supreme Court's decision in Endrew v. Douglas County School District. So I thought that would be a good thing to talk about, especially what special ed leaders need to know and why they need to know it. Of course, the primary requirements of the IDEA, the Individuals with Disabilities Education Act, and the current and the crucial obligation of special ed leaders, principals, anyone associated with special education is to provide a special education that confers what the law calls a free, appropriate public education. Now, special education is a very litigious area, as I'm sure many of you know. And we comprise probably about 10 to 12% of the public school population. Yet a gentleman from Pennsylvania, Perry Zurkella, a number of years ago, looked at the total amount of litigation in education and found that special ed, which accounts for 12% of the population, accounts for about 85% of all litigation in special education. And what makes this recent decision so important is that of all the litigation in special education, probably 85 to 90% of it or more is on FAPE, is on FAPE issues. In other words, what is a free, appropriate public education? And for those of you who are principals, and I know you're very familiar with the individualized program planning team, every piece of litigation that has ever come down in special education always starts at the IEP table, where there's a disagreement between school officials or school personnel and parents about what constitutes a free, appropriate public education for the parent's child. Now, one of the reasons, in addition to being, as Carol said, in addition to being a professor at the University of South Carolina, I am also what's called a state-level review officer. We in South Carolina are one of 7 states that still have what is called a 2-tier system of litigation in special education. As you all know, when there's a disagreement that arises between school personnel and IEP team personnel regarding an issue of FAPE, the parents or the school district may request a due process hearing, which in South Carolina is held at the local school district level. And if you've ever been in a due process hearing, you know how fun those are, action-packed, thrill a minute. But essentially, you have an impartial hearing officer who acts as a judge. You have attorneys for both sides, discovery, you have witnesses, cross-examination. And in South Carolina, we have a system where once it's been held on the local agency level, the appeal doesn't go to federal or district court. It first goes to the State Department of Education. And that's what my role is now as a state-level hearing officer, so I get to hear appeals of cases. And I can attest to the fact that the majority, by far, are on free, appropriate public education, which really makes this decision such an important one. Now, first off, I've been around since 94-142 was passed, when it used to be called the Education for All Handicapped Children Act. At that point, the primary obligation of special educators was to provide an education that conferred a FAPE. And this is the way the individuals, then the Education for All Handicapped Children Act, now the Individuals with Disabilities Education Act, defines FAPE, is that it is a special education and related services that are provided at public expense, meet the standards of the SEA, and that's kind of a nod to the fact that education is really the prerogative of the states, and although all states have their own version of the idea, essentially if your version of the idea or South Carolina's version of the idea special ed law goes a little beyond the idea you have to follow that. However, state law cannot go beneath or offer less than the Individuals with Disabilities Education Act. Also, it includes preschool, elementary, or secondary education, and very importantly, is provided in conformity with the IEP. Now, when I started, almost immediately upon the individual, with the passage of PL 94-142, we started to see litigation. And what I mean by litigation is due process hearings, state-level hearings, federal or state court cases, and normally special ed cases are brought in the federal courts. FAPE became a contentious issue almost immediately. And in fact, in 1982, the Supreme Court heard the first case in special education, which was Board of Education of the Hendrick Hudson School District v. Rowley. That was 1982. And this is Amy Rowley, who by all counts was she was a gifted child with a measured 142 IQ, academically very able. However, she was profoundly deaf. And the first case brought to the Supreme Court that the Supreme Court heard was Amy provided with a free, appropriate public education under this new law, the Education for All Handicapped Children Act. And it involved Amy's parents requesting a sign language interpreter because although she was in kindergarten, they believed, as she went through school, she was an excellent lip reader, but she needed the service of a sign language interpreter. And so this went through a due process hearing, a federal district court in upstate New York, the U.S. Court of Appeals for the Second Circuit, wound up in the Supreme Court. Now, the interesting thing about this case is the parents wanted their version of what a FAPE was as follows: that a FAPE, a free appropriate public education under the law, must provide youngsters with disabilities with an equal opportunity as that provided to non-disabled students. And this opportunity must allow them to achieve to their maximum extent, maximum potential. Well, the school district did not see it that way. They saw it as being, we need to provide special education related services that allow Amy to benefit, but we don't have to provide the maximum. Well, this case wound up, as I said, going to the Supreme Court, and the Supreme Court said a number of very important things. And the reason they're so important is once the Supreme Court hears something, of course, that's the law of the land. That I, as a hearing officer or any judge on the appeals court or a district court, basically has to follow what the Supreme Court says they have to do. And what they did is they defined what a FAPE was. Because if you look at this definition, it's not exactly a model of clarity. It doesn't really tell us what a FAPE is. So the Supreme Court decided we're going to have to define this. And one of the very first things they said in their decision, which was written by William Rehnquist, is that special education, or FAPE, does not mean maximization of benefit. And a quote from Rehnquist's decision: the requirement that states provide equal educational opportunities would thus seem to present an entirely unworkable standard, requiring impossible measurements and comparisons to require the furnishing of every special education service necessary to maximize each handicapped child's potential is, we think, further than Congress intended to go. And so what they concluded is that the FAPE requirement of the idea, then the EAHCA, requires that school districts provide a basic floor of opportunity that consists of access to specialized instruction and related services which are individually designed to provide educational benefit to the handicapped child. And the next thing that the Supreme Court did is they developed a test. The Supreme Court often likes to do that as a guide to lower courts to rule in similar cases. So the two-part test they developed literally has to be applied by every special ed due process hearing officer, state review officer, judge, at a circuit or a federal district court level in a FAPE case. And this is the two-part test. The first part is, has the state, the school district, complied with the procedures set forth in the law? So all of us in special ed know we have many, many procedures that we have to address in developing a child's FAPE. You know, the parents have to be involved. We have to have the IEP team. Certain members have to be on the IEP team. We have to have some certain components within the IEP. Those are some of the procedures of the law, and we need to follow those. When the Supreme Court applied that part of the test to the Rowley case, what they found out is the elementary school, which is called Furnace Woods Elementary in Peekskill, New York, had done a very good job of meeting the requirements, the procedural requirements of the law. In fact, they had done everything the law requires. Therefore, the Supreme Court held that the school district had met part one of the test. They had met the procedures. Then they went on to part two. The part two was a little more difficult question. Is the IEP reasonably calculated to enable the student to receive educational benefit? And this is where many people felt that kind of the Rowley case was a little bit of an unfortunate first case to be heard by the Supreme Court. Why? Because Amy had 142 IQ. She was academically very able. She was gifted. She did better than any of the other students in her class. So essentially, they didn't really have to answer that. They didn't have to really answer, was the IEP reasonably calculated to provide educational benefit? Because of course it was. She did very well. She passed from grade to grade. She was at the top of her class. So they kind of said, well, yeah, clearly it must have. Although they also said that this test, what we are saying here, only applies to Amy. You have to decide educational benefit on a case-by-case basis. Well, as time has gone by, the first part of the question has never been particularly difficult for courts, for hearing officers to answer. What are the procedures followed? I mean, you just basically, I know as a hearing officer, a review officer, look at the procedures of the law, look what the school district did, and do kind of match the sample. Did they do everything they were supposed to do? So the first part of the test was relatively easy. The second part of the test, however, proved quite difficult. And why is that? It's because Amy was not your typical special education student. Gifted, academically able. Most of the students we have are not in the same boat as Amy. They're having some really significant problems. So therefore, it becomes, when FAPE cases go to court or hearings, it's up to the hearing officer or the judge to determine, did the child receive educational benefit in accordance with the law? Well, over the years, what has happened is that a number of circuits have issued FAPE decisions in which they, as they had to do, used the two-part Rowley test. But when they got to the second part of the test, educational benefit, the circuit started viewing that part of the Rowley test in a different way. Essentially, most circuits started using a real low standard of educational benefit. In other words, they said that, well, if there's just some degree of benefit, that meets the second part of the Rowley test. However, there were two circuits, the Third and the Sixth Circuit, that had the opposite view. They said, no, no, no. A little bit is not enough. Congress would not have spent millions of dollars to allow children to just get a little bit of benefit. We believe it has to be meaningful benefit. And they defined it in a very different way than the other circuits that had a low standard. And we had some circuits like the Ninth and to some extent the Fifth that were kind of confused, because a circuit court is comprised of 12 judges who are broken into panels of 3, and they hear cases from all over the circuits. In the Ninth Circuit, we had some panels saying meaningful and others saying low standard. So we had a real difference between the circuits in what exactly is this educational benefit thing. Well, whenever there is a difference in the circuits, that makes it much more likely that the Supreme Court is going to step in and try to settle this difference. This is what happened in a case in 2014 out of the 10th Circuit. Oh, I want to go back here for a second. And you can see you're in the 7th Circuit. This case I'm going to talk about was from the 10th Circuit. And essentially, the 10th Circuit case was a case called Endrew F. v. Douglas County School District. Endrew F. was a 4th grade boy who was educated in the Douglas County School District at a school called Summit Hill Elementary School in Denver, Colorado. And Endrew had he had autism. He had been diagnosed with autism at age 2 and ADHD at age 3. He had some very significant problems. He did have language. He was able to do some amount of academics, and he was doing fairly well. He had been educated in the Douglas County School District through preschool through 4th grade. He had an IEP from 1st grade to 4th grade. Well, in 4th grade, his progress essentially stalled. He was not doing very well academically. He had increasing problem behaviors that were really very concerning to the parents. And they had an IEP meeting with the school district personnel. And what they told the school district personnel is, you know, this IEP from 3rd to 4th grade was basically the same. They had the goals in the 3rd grade IEP for Andrew, called Drew by his parents, were essentially the same as the 4th grade goals. And they said, we do not believe this program is conferring FAPE. It's Andrew's he's not getting any educational benefit out of the program. And what Andrew's parents decided to do was pull Drew and have him educated in a private school called Firefly Autism House in Denver, Colorado. Firefly Autism House is a private school primarily just for students with autism. They have behavioral experts on the staff, and in fact, Drew attended there for his 4th grade, and he actually did quite well. And at that point, the parents said, you know, we really want Drew to be educated in the public schools. So they went back to the Douglas County School District, had an IEP meeting at the middle school, at Summit Hill Elementary School, and talked about writing a new IEP that contains some of the components that the Firefly Autism House had, which included behavioral programming, a behavioral intervention plan, actually some real rigorous behavioral programming, and more academic and functional programming. Unfortunately, the parents in the school district were not able to come to kind of a collaborative decision on Drew's IEP. And therefore, the school district essentially decided to keep the same IEP they kept in 4th grade. The parents, being upset by this, then again pulled Drew, sent him back to the Firefly Autism House, and where he continue to receive his education. But as parents may do, and I mean certainly parents, if they are in disagreement with a school, may pull their child and put him in a private school. But it's at their own risk, because if of course a public school places the child, then the public school pays for it. But in this case, it was a unilateral placement by the parents, so it's paid for so the parents paid for it, but they also filed for a due process hearing asking for tuition reimbursement at Firefly Autism House. They went to hearing, and the hearing officer disagreed. See, one of the things in a tuition, this now became what we call a tuition reimbursement case. If parents want to unilaterally pull their child and put him in a private school, they may do that, but they do it so at their own risk. But if they sue for tuition reimbursement, they have to prove 2 things. Number one, that the school district did not provide FAPE, And number two, that the private school did provide a good education. And so this went to the due process hearing officer, and the first thing he said, well, the first of the two-part test is I have to determine, did the school district provide a FAPE? Well, if you think back to this standard, the 10th Circuit here had a very low standard of what educational benefit was. And so when the hearing officer took this case, he said, well, the school did do a good job of following the procedures, and now when I have to answer the second part of the Rowley test, I have to use the 10th Circuit standard, which is a relatively low standard. And he had to answer, do I believe the school district offered FAPE? And because of that low standard, remember, a little more than some educational benefit, he said, yes, the school district had offered a FAPE. Well, the parents losing at that level filed an appeal with the federal district court for the District of Colorado, who then heard the case, and they agreed with the hearing officer because using this low standard of educational benefit, they said, well, the school had met the FAPE standard because they provided some educational benefit. The parents then, undaunted, appealed to the United States Courts of Appeal for the 10th Circuit, which is that whole area around Colorado. Now, again, the 10th Circuit standard was this. A few years before this case, the 10th Circuit had a FAPE case in which they wrote in their opinion, the educational benefit mandated by the idea must merely be more than de minimis. That phrase was authored by Neil Gorsuch, who at the time was on the 10th Circuit Court of Appeals, of course, is now on the Supreme Court. So the parents, appealed to them saying the school made procedural and substantive errors, did not confer FAPE to Endrew. The 10th Circuit, using this low educational benefit standard, did hold for the school district. So the school district had won at the due process hearing, at the federal district court level, and the 10th Circuit Court of Appeals. The parents decided to exercise their one last appeal, and that was to the United States Supreme Court. And they weren't really even concerned about the tuition reimbursement anymore. The parents said what we wanted the Supreme Court to answer was, what does educational benefit mean? What is a school district required to confer on a child for them to receive a free, appropriate public education? So on December 22nd, 2015, the parents appealed to the United States Supreme Court asking this question: what is the level of educational benefit school districts must confer on children with disabilities to provide them with a free, appropriate public education guaranteed by the Individuals with Disabilities Education Act? And on September 29, 2016, Supreme Court granted certiorari, which essentially meant we will hear the case. This is a big deal because out of 8,000 to 9,000 cases appealed a year, they maybe hear 80. So when they hear a case, it's very important. And one of the reasons they probably heard it is because there was this difference between the circuits. And what do we mean by educational benefit? Well, on January 11th, 2017, 8 Supreme Court justices heard the case of Endrew F. v. Douglas County School District. Justice Gorsuch was not yet seated on the Supreme Court. And so as luck would have it, I happened to have to be in Washington, D.C. on the 12th and 13th. So I quick called Delta up and I said, can I get there on the 10th? And they said, yes, certainly. So I got to D.C. on the 10th and I found a little hotel room right by the Supreme Court. And I was determined, I'm going to go hear this case. And one of the things, when you want to hear Supreme Court, there's no distinction between important and unimportant persons, because essentially what you have to do by Justice Breyer's tie there is you have to line up. And some cases, people have lined up for days. So, because only 50 people are allowed into the Supreme Court. And the lines tend to look like this. They get very long. And so I thought, I really want to hear this case. This is an important case. So I got there at 5 o'clock in the morning, 30-degree weather, and sat on the Supreme Court steps until they opened the gates, or the doors, at 9:45. And there was only two gentlemen ahead of me. So I knew I was bound to get in. And sure enough, I was the third person in, got seated at the Supreme Court, and heard the oral arguments, which truly was one of the fascinating experiences of my life. Now, I do have to say, though, that if we look at the two gentlemen in front of me, 1 and 2, weren't there anymore. Instead, two friends of mine from the Council for Exceptional Children, Deb Ziegler and Katie Grady, were there. And I said, well, what happened to the gentlemen who were there? Well, I didn't know this, coming from Little Columbia, South Carolina, and you maybe do, in Terre Haute, you maybe do have line standers. But in Washington, you can hire line standers at $40 an hour to stand in line for you. So, but I wound up shivering through 5 hours of weather, but it was part of the experience, so I'm glad I did it anyway. And this last gentleman is a friend of mine named David Bateman, who also made it in. He didn't get there till 5:45, so he was kind of a piker, but he also made it into the Supreme Court, and that is the Supreme Court. We were seated back here. Of course, the justices sit up there. Fascinating experience, because the court crier comes in and says, "Oyez, oyez, oyez." God bless the Supreme Court of the United States. The Supreme Court, the Chief Justice, the Associate Justice are now sitting in session. And at 10 o'clock, the curtains open. The justices all come up and take their places. Oyez. The court crier then says, "Oyez, oyez, oyez." Everyone having business before the court is admonished to come before the court. And arguments last for 1 hour, and at 1 hour they get up and go. And attorneys prepare 30 minutes, and they usually maybe get in a minute into their argument, and they start getting questions from the Supreme Court justices. And in fact, David and I, who happen to be sitting together, I'm sure you probably all heard Nina Totenberg on NPR, where she will talk about Supreme Court decisions and try to glean what the decision may be based on the questions of the judges. And Elaine Kagan and Ruth Bader Ginsburg very clearly thought educational benefit means more than just some benefit. As Ruth Bader Ginsburg said, she believed it means a standard with a bite. They were clearly in favor of a higher educational benefit standard. But in the next two gentlemen, which were Justice Breyer, who is pretty much routinely more of a liberal voice on the court, was very much in favor of increasing benefit. But so was Justice Roberts. And he gave what David said was the closest he'd ever heard to Supreme Court humor, when he said, he pointed to the attorney for the school district and said, "You folks want some benefit." Then he pointed to the attorney for the plaintiffs, for the parents, and said, "But you folks want some benefit," emphasizing that they're asking for more benefit. And very much they really believe that too. And the last judge that was clearly in favor of a higher standard was Sotomayor. Sonia Sotomayor, who said, "IDEA provides a clear standard. The problem is coming up with the right words." So that was the Supreme Court's task. We thought it would probably be a 5-3 decision, since there's only 8 justices, that it would be in favor of a high standard. But as Sotomayor said, we need to come up with the right words to help school districts, to help judges and hearing officers rule on FAPE cases. Well, what actually happened is that Justice Roberts wrote a very short 16-page decision that was actually an excellent piece of work. I mean, he's an excellent writer. And he put his finger on the real crux of the problem right away. He said, in Rowley, we decline to endorse any one standard for determining when students with disabilities are receiving sufficient educational benefit to satisfy the requirements of the idea. That more difficult problem is before us today. And what the court did, and they came out on March 22nd, 2017, with a unanimous decision, rejecting the low standard, rejecting the merely more than de minimis standard, and they vacated the decision and remanded the case back to the 10th Circuit. What that meant is they said, we have a new standard, you have to rule on this, but we're not going to tell you how to rule, you have to redo it. You have to essentially redo the case in line with our new decision. And this was the new standard. These were the right words, as Sotomayor said. To meet its substantive obligation under the idea, a school must offer an IEP reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. So no longer do they say educational benefit. Now they're saying progress appropriate. Progress appropriate being different in that progress implies movement forward where educational benefit really did not. That's why you had the big differences between the circuits. Well, there's a number of takeaways, I think, that we need to understand as special ed leaders from this decision. The first is the de minimis or trivial educational benefit is no longer good law. Circuits, due process hearing officers cannot use that trivial lower standard. They have to use a higher standard now. Now, in terms of what exactly the Supreme Court said, is that a student offered an appropriate program providing merely more than de minimis progress from year to year can hardly be said to have offered an education at all. And a substantive standard not focused on student progress would do little to remedy the pervasive and tragic academic stagnation that prompted Congress to act in 1975. The idea demands more. So that's the first major takeaway that we as special ed leaders need to understand, is there is now a higher standard that hearing officers, that courts will apply when using the FAPE standard. And because 90% of all cases heard start at the IEP and involve the issue of FAPE, educational benefit, courts and hearing officers are going to be using this new high standard. But on the other hand, the Supreme Court did not accept the maximizing standard that the parents had asked for. Remember, Endrew's parents, as Amy Rowley's parents, had asked that the Supreme Court say that ideas about equal educational opportunity that allows a handicapped or a disabled child with disabilities to achieve to their maximum extent possible. The Supreme Court did reject that. Essentially, they said nobody can determine equal educational opportunity or if maximum benefit, if it gives maximum benefit. But what we can do is determine if a program confers progress. So in essence, what the Supreme Court did is they did not overturn Rowley. They clarified the Rowley decision. They did not replace it. And this is how they replaced it. In fact, the Supreme Court, Justice Roberts in his decision said, we find little significance in the court's language in Rowley concerning the requirement that states provide instruction calculated to confer some educational benefit. Obviously, the district courts had been horribly split over what does educational benefit mean. Well, the Supreme Court essentially, in the Endrew case, changed the second part of the Rowley test as follows. So anytime I'm reviewing a case or a due process hearing officer's hearing a case, or a federal district court judge, or a state court judge, or a federal bank, or 3 judges of appeals at the U.S. Circuit Court of Appeals level is hearing a FAPE case, what they will do is they will apply what we could now call the Rowley-Andrew test. And that is the first thing they're always going to ask. In the development of the IEP, did the school district comply with the procedures set forth in the law? That's still going to be an important part. But the second part is now the Endrew contribution. Is the IEP developed through the ideas, procedures, reasonably calculated to enable the child to make progress that is appropriate in light of his or her circumstances? Another major takeaway is we're not going to really know what the full implications of this decision are until we hear hearing officers, judges, appellate courts, applying the Endrew standard to the facts presented in future FAPE litigation. And in fact, a colleague of mine at the U.S. School of Law are doing a canvassing of decisions, and there have already been 100 FAPE decisions heard in the federal courts applying the Endrew decision. So once we start getting those, then the full implications of this decision will be made clear. But nonetheless, we have to understand the Supreme Court did not give a formula for hearing officers or judges to do. Essentially what they gave them is a new standard. They said, we will not attempt to elaborate on what appropriate progress will look like from case to case, because the adequacy of a given IEP turns on the unique circumstances of the student for whom it was created. Now, the courts do play an important role. Hearing officers play an important role. One part of this role, according to the Supreme Court, is that a reviewing court may fairly expect those authorities to be able to offer a cogent and responsive explanation for the decision that shows that the IEP is reasonably calculated to enable the child to make progress in light of his or her circumstances. Now, last major takeaway I have from this is we as special ed leaders have a lot here. It gives us a lot of guidance in developing IEPs that meet the Endrew standard. So what I want to end with is recommendations to special ed leaders, to principals, to IEP team members, school personnel to understand are extraordinarily important in making certain that we meet the requirements of the Endrew decision. And the first recommendation is that we need, as special ed leaders, to continue to train and prepare IEP teams to avoid procedural violations in the development of the IEP, because these procedural violations in and of themselves could constitute a denial of FAPE. So remember, like Rowley and Andrew all began at the IEP team table. That's where these cases began. It's extremely important that we make certain that our IEP team members, our principals, understand the procedural requirements of the law. And I just put down a few procedural errors that in and of themselves could be serious enough. And I'm sorry I just added this, but I was planning to talk about it, but I'm not going to go through it a lot because we don't have that much more time. But just a few comments. IEP membership is incredibly important. You want to make certain that the IEP team are all present at the IEP meeting, especially those initial IEP meetings. There's an attorney that named Julie Weatherly, who works primarily with school districts, and she has used the term in working with her school districts. Remember this, the role of the general ed teacher is not just to have a warm butt in a chair. They have to be involved. So there have been cases that have turned solely and been decided against school districts because the proper team membership wasn't there, and particularly the general education teacher. So that's a very important consideration. Make certain that you have fielded an appropriate IEP team. I remember when I was a teacher, oftentimes the general ed teacher would happen to be the teacher that walked by the room and unfortunately made eye contact with our principal, and he said, "Get in here and sit for a few minutes." You can't do that. They have to be involved. Secondly, failing to ensure a continuum of placements. And this is really apart from, it's more about least restrictive environment, but it's very important that school districts have an entire continuum of placements. Failure to include important components in the IEP. We know of all the components that need to be on the IEP. You can go to the IEP Resource Center and find all that information out. Those components have to be there. Failing to include them could be a serious procedural error. Predetermining services or placement. So oftentimes you'll hear attorneys talking about the spaghetti strategy, which is throwing as much spaghetti up against the wall and seeing what sticks. Predetermination is going to stick. If an attorney can prove to a hearing officer or a judge that as a school district we predetermined the placement or the services, we will probably lose. That is a serious, serious procedural mistake. That doesn't mean we can't talk about things amongst ourselves. It just means we cannot make final decisions until the parents are involved in the IEP meeting. Placing a student prior to determining programming. That's a practice attorneys call shoehorning. In other words, we're going to decide on the placement, then we'll decide on the program. Since 1975, the idea said that gets it exactly wrong. You have to decide on the program, on what's going to constitute a FAPE, then you decide on the placement. To do it the opposite way is a procedural error. And the last one I put is really not a procedural error, but it is almost another FAPE error in of itself, and that's failing to implement a material part of the IEP. We must remember the IEP is not a list of suggestions. When we have listed in the IEP the services we'll provide, if there are program modifications in the general ed, we have to provide them. For example, if we have the tests will be read in all general ed classes to a child, they'd better be read to a child. It's not up to the teacher to make that decision. Once it's in the IEP, that has to be implemented. The Ninth Circuit just came out, Circuit Court of Appeals, just came out with a decision that said the IEP is like a contract we drop with the parents. It's not a contract that guarantees success. IEP, the idea does not guarantee that students will succeed or they'll meet their goals. It does guarantee, however, that we will do what we said we did. We were going to do. So we have to implement the IEP as written. That's why I think Indiana's IEP at a glance is a really good thing, because I remember when I was a teacher, the principal before school would come on and said, Mr. Yell just had an IEP meeting for such and such. All general ed teachers, please come down to his office, check out the IEP and read it. Well, how likely was that to happen? Not extraordinarily likely. General ed teachers are pretty darn busy folks. So anything we can do to communicate to all teachers involved what your responsibilities under the law are on this IEP are, it's very important, because failing to implement portions can lead to a finding against a school district. So that's very important. It's also important to understand, as Barbara Bateman said back in this year, because the IEP process develops and formalizes a FAPE for a student with disabilities, the IEP is so important that a failure to properly develop and implement it may render a student's entire special ed program invalid in the eyes of the courts. Now, let me go, I'm going to go back to this one just for a second. Back to these procedural errors. Very serious, as I said. Now remember, The Rowley-Andrew test is the first part. Did the school follow the procedures? The second part is, did the school's IEP, was it reasonably calculated to enable a child to receive educational benefit? If a court finds that you didn't do those things, it doesn't matter if the child benefited. You committed a serious procedural error that could in and of itself be grounds to rule that you did not provide FAPE. Very important. Also, it's important to understand that recently a couple of courts have come out with this new idea that even smaller procedural errors, if they're committed in a number of procedural errors, even if they're not a big deal, by themselves are a big deal. So procedurally, very important. And the most important procedure is this. That's my second recommendation, that we need to ensure meaningful parental involvement in IEP meetings and that a parent's opinions are considered in establishing the child's IEP, educational, academic, and functional goals. Now, we don't have to agree with the parents. You know, I often talk about, I remember back when I was in Minnesota at an IEP meeting where parents of a child with autism had read on the internet about the benefits of dolphin therapy. Honest to goodness, wanted the child sent to Florida to partake in dolphin therapy. Well, you know, we didn't do that, and that's fine, but we listened to them, and that's the important part. You have to consider a parent's opinions in developing their child's IEP. Now, just a couple quotes from the Endrew decision. An IEP must be drafted in compliance with a detailed set of procedures that emphasize collaboration among parents and educators and require careful consideration of the child's individual circumstances. And the last one. Judicial deference to school authorities will depend on their having provided parents in the IEP process with an opportunity to fully air their opinion on the requisite degree of progress. So we need to collaborate with parents. Now, I know as a teacher, as long as I was, sometimes it was very difficult to get parents there. Sometimes we had no idea who they were. That means we have to go ahead and write the IEP. But you know, the state, Indiana, South Carolina, we all have procedures that we have to follow if we cannot get the parents involved. We just need to remember that we document and follow those procedures. Number 3, when developing the content of a student's IEP and subsequently reviewing and revising it, be certain that the present levels of performance and the annual goals that are based on the present levels are based on relevant and current information. And this is essentially what, these are a couple quotes from the Endrew decision. A focus on the particular child is at the core of IDEA. And an IEP is only constructed after careful consideration of the child's present levels of achievement, disability, and potential for growth. Courts have found IEPs invalid solely because of inadequate evaluations and inadequate present level statements. Why? Because, as one court said, that's like a foundation of a house. If the foundation is faulty, the rest of the house is faulty. So if the foundation and the evaluation, the present levels, is faulty, the rest of the IEP is faulty. This is just, I just decided to include these last night. There are a couple gold charts from IEPs that were written in Greenville, South Carolina. And this particular chart had a baseline developed for the child. And that's a really good way to think about the present levels of performance as a baseline, because that's where we're starting. And we expect growth in 1 year's time, given a good special education program. But if we don't have a way to measure growth, if we don't have an accurate present levels statement, we can't really measure growth. Now, in light of the child's circumstances, that was the phrase used over and over again by the Supreme Court, that our decisions have to be based on the individual child's circumstances. And very important, and sorry I just added this one today, but there was a quote I took from the IDEA Regulations 1997 in a question and answer document. about what is the relationship of the present levels of performance to the rest of the IEP. There should be here's what the Department of Education said, there should be a direct relationship. In other words, if there's a problem with reading, that needs to be addressed in the goals, it needs to be addressed in the services and the way we monitor progress. Recommendation 4, we ensure that the IEP goals are challenging, appropriately ambitious, and measurable. The challenging and appropriately ambitious are 2 words that the Supreme Court used a number of times. And they also had this phrase: the essential function of the IEP is to set out a plan for pursuing academic and functional advancement. In other words, it's not just academic, it's functional needs too, communications, behavior, and all the goals will differ from each child, from child to child. Every child should have the chance to meet challenging objectives. And oftentimes, when I've presented to teachers, especially here, we don't want to write goals that are too ambitious, because then the child won't meet them and we'll have a real problem. Remember this, the IEP is not a guarantee of success. No, I have never, ever, ever read a decision where a school district lost because their goals were too ambitious. However, they often lose if they're not ambitious enough. So I always tell teachers, err on the side of ambition. We want to be reasonable, but we want to be ambitious, because now, remember, that's what the Supreme Court is saying, challenging objectives. That was just another I took from this Greenville IEP, where they had the baseline, they had a year's worth of growth, and that X over there marked where the peers were on this particular measure. If I, as a hearing officer, got that projected rate of growth, I'd say that's a challenging objective. The next recommendation is that teams must continuously monitor and measure a child's progress on annual goals and benchmarks if available. That is, our goals have to be measurable. They can't be, and there's many cases that I could find that will say things like, declared IEPs were invalid because they had things like, Johnny will improve in reading. Well, that's not measurable. You can't measure it. If you can't measure it, how can you show progress? So very important that goals be measurable. And I was so pleased last week, or a couple of weeks ago, when I was at the Focus to Inclusion, I looked at their at what they have coming up at the IEP Resource Center, and one of them is writing measurable goals. That is so important. We cannot show progress unless we have measurable goals. Recommendation 6, when progress reports and other data do not reflect that an annual goal will be met, reconvene the team, determine why, make needed instructional changes, and continue to collect data, because, as the Supreme Court said, a substantive standard not focused on student progress would do little to remedy the pervasive and tragic academic stagnation that prompted Congress to act. So if I, as a hearing officer, see the IEP team has collected data like this that shows a child is making progress to the goal, they've met the Endrew standard. On the other hand, if they show something like this and the child is not making goal, and, well, they've never met or revised the IEP, I would say that goes a long way to show that the team is not making good faith efforts to meet the Endrew standard. Now, remember I said that the Supreme Court did not overturn the Endrew decision. They remanded it. They said, 10th Circuit, we have a new standard that you have to go by. So we want you to rule or look at this case and make a new judgment in terms of our new standard that they developed. Well, what the 10th Circuit did is they kicked it down to the federal district court. They said, we therefore vacate our prior opinion, remand to the United States District Court for the District of Colorado for further proceedings consistent with the Supreme Court's decision. And on February 12th, 2 weeks ago, The federal U.S. District Court for the District of Colorado ruled on the remand. And Judge Babcock wrote in his decision, I conclude that Endrew and his parents have met their burden to prove that the district's April 2010 IEP failed to create an educational plan that was reasonably calculated to enable Endrew F. to make progress, even in light of his unique circumstances. The IEP, therefore, was not appropriately ambitious and did not give Endrew the chance to meet challenging objectives. Accordingly, I reversed the administrative court agency decision that denied Endrew and his parents' request for reimbursement of his tuition, transportation costs, as well as reasonable attorney's fees and litigation costs. So in other words, what Judge Babcock did is he said the Denver County School District failed to provide FAPE. And because they failed to provide FAPE, they owe tuition reimbursement, court costs, litigation fees, attorney's fees to the parents. The Firefly Autism House, back in fourth grade, when Endrew was in fourth grade, he just turned 18 years old. That's how long the courts take to rule in these cases. He's been there every year since fourth grade. They charge $70,000 a year for tuition reimbursement. So you can see the school district is going to be on a pretty big hook. But that's not even close to the end of the decision, because the attorney or the judge also ruled that they have to provide reasonable attorney's fees. Does anybody have a guess at what reasonable attorney's fees from a hearing to the Supreme Court will be? I would say probably $3 million. So, I mean, it's going to be a huge, it's a huge decision. And it's huge in that it really, for the first time, gives us some guidance as to what we need to do. The last thing I wanted to say is the U.S. Department of Education found this decision so important that they issued a question and answer document on the decision. What they did is they had 20 questions and answered them. These are officials at the U.S. Department of Education. So I'd urge you, go into Google, put U.S. Department of Education, Endrew, question and answer, and you will get the document. PDF form comes up. It has 20 excellent question and answers, very user-friendly, kind of a thing that would be good for teachers and administrators to read, especially the last 10 questions, which deal specifically with what this means for IEP teams. If you want to read more about Endrew, oops, went the wrong way. If you want to read more about Endrew, go to SCOTUS blog, just put it in Google and Endrew, and you'll get a page on the decision that has everything you want to know about it. So that is our time, so I'll be around for the rest of the day. This is an important decision. Again, we can't say exactly what this is going to mean, but it's going to be more in terms of benefit, of progress that we have to provide to our students. So as special ed leaders, we need to really understand and take notice of this decision. So thank you very much. Thanks.